Okay, welcome to our last chapter, chapter 35. We're going to be talking about employment discrimination and diversity. And again, this is, I think, one of those areas that probably there's some real changes coming in the future for some of this, just to be aware of it. So we'll talk about what a lot of the current law is, and then we'll talk about how things may or may not be changing a little bit. We'll see if we can't prognosticate or predict the future. So we're going to talk about employment discrimination and diversity here. So at the core of this, of course, is the Civil Rights Act, which is called Title VII. So Title VII is the federal protection for groups of people that are a protected class that you cannot discriminate against. It essentially gives them a certain advantage in the law, where in the past, if you were being discriminated against, you kind of had to prove that they were acting against you. This places the burden on the employer saying, okay, you've got to make a good faith showing that this wasn't discriminatory. So it kind of subtly shifts the balance a little bit. So you are not allowed to discriminate against one of these protected classes, and we'll talk about what these protected classes are. But this protection is going to really expand as time goes on. I mean, it really at first was looked at primarily as these protected classes as racial. And then gradually other issues such as gender, sexual orientation, ethnicity, religion, all these kind of got bundled together. Now, one of the interesting things that happened back in 2011, and this, if you want to look it up, this is, I believe it's Walmart Stores versus Dukes. I want to say it's 564 U.S. 338, came down in 2011. And this placed significant limits on the rights of employees to bring discriminatory claims. Basically, it allowed individual actions to continue, but placed major limits under class actions. And class actions were one of the major reasons law firms took these cases, because if an individual sues, there might be a few hundred or a few $1,000s involved. But if you can show a systemic pattern, and you had dozens or hundreds of employees, then the recovery would be large enough for firms to be more interested in the cases. But in 2011, in the Walmart case, the Supreme Court put some real limits on those actions, and that's one of the results of having the people on the court that are on the court. Okay, so who is covered under Title VII? Let's talk about that. Okay, sorry, a bit of an interruption there, but I don't know if you'll notice it, but thought I'd mention it. So we're talking about who is a protected class under Title VII. So right now, the federal government has certain set definitions, and then there's been some extensions of this. And I'm going to leave the extension alone pretty much, but I'm going to focus on what's clearly outlined. That is, you can't discriminate if you were over a certain age. Typically that's going to be in the 50s. Gender, and that's a contentious one there. Race, color, religion, and national origin. Now this applies at any stage of employment. So it can be the opportunity to hire someone, the opportunity to be promoted. Any of those are covered if you're in one of those protected classes. Okay. Next, how is this all enforced? Well, most of this is going to be enforced via the EEOC. The EEOC is the Equal Employment Opportunity Commission. So essentially, this is something that functions pretty much everywhere in the United States. And basically, a federal agency is going to exist in Raleigh. There's one in Raleigh. And what you do is, if you feel you are a member of one of these protected classes and that you have been discriminated against in being hired, being fired, being promoted, how you were treated, opportunities, you go down to the EEOC and you file a claim. The EEOC then has investigators who will investigate, and if the EEOC declines, if they decide they don't want to, or if they decide they're not going to start a case, after 60 days after you file your EEOC complaint, you are free to explore alternatives, which means you yourself can sue and try to enforce your rights. Generally, the EEOC only focuses on priority, and mostly what it does is it seeks out-of-court settlements. It generally is not wild about going to court. And of course, that's really going to depend upon who's really controlling the federal government at the moment. Now, let's talk about intentional and unintentional discrimination. Okay, so if you're arguing that you are intentionally discriminated against, what you want to show is that first, you are a member of one of these protected classes, that you applied for a job for which you're qualified. So if I say, well, I want to be hired to fly a plane, but I have no capability, I have no pilot's license, even if you could show that somehow or other I was rejected because of my gender or my race, it wouldn't matter because I'm not qualified for that job. You have to be rejected, and then the job has to be left open, typically. That gives you a prima facie. Now, prima facie is just Latin meaning on its face, and it says you now have an expectation that you can go forward. Once you establish the prima facie case, we shift the burden to the employer. Now, this isn't an undue burden, it's not a heavy burden. We're simply saying that the employer now has to show why you were rejected. And if they can't, then they're going to have a real problem. Okay. Unintentional discrimination is a little different. Unintentional says this is a supposedly neutral criteria. So as opposed to saying we only hire men, we only hire people under 40, what you show is there is a criteria for the job, and it's theoretically a neutral criteria. But for some reason, 4/5 of any minority or protected class in comparison to the majority population cannot pass this test. So let me give you an example that happened to the San Francisco Fire Department. They had a rule that, and I'll make it a little simpler than it actually was. They had a rule that you had to be able to throw a 100-pound sack over your shoulder and climb up a ladder. And what it turned out was this really made it almost impossible for many women to become firefighters. So they were sued about this because it excluded 4/5 of women from applying for the job or getting a job as firemen. And they said, well, look, this is neutral. Men and women both have to do it. Well, then they inquired. They said, okay, how often do people do this? How often do people throw someone over their shoulder and climb a ladder? And the answer was, well, virtually never. We've pretty much done away with that. We don't have that being done. Well, obviously at that point, the San Francisco Fire Department's in a lot of trouble. Okay, so when we talk about discrimination based on race, color, or national origin, you also have, it can't be intentional or unintentional. We don't allow either one. But you also have a cause of action under a different federal statute. Now, Title VII has limits on damage. If you really have a clear cause of action, you may want to sue under 42 U.S.C. 1981 because unlike Title VII, there's no limits on damages. The only good defense to a discrimination based on race, color, and national origin is substantial, demonstrable relationship to job or job qualifications. And you can really see that that's not going to work for race. There's no scenario you can construct there. Discrimination based on religion, this is probably the weakest of the protections. First of all, in order to sue, you have to have a sincerely held belief that you claim has resulted in discrimination in hiring, firing, promotion, whatever. In this case, the employer must make a reasonable accommodation to your beliefs. So if you say, well, my religion says I can't work from sundown on Friday to sunrise on Monday, and everybody else in the company works every other weekend or something, is it reasonable to say, well, I'm sorry, we're not going to tell these people they have to work every weekend so you can have every weekend off? They must reasonably accommodate your beliefs. And this really means, this kind of out for employers, that employers generally win discrimination based on religion cases. Gender, you essentially, it's very difficult. You have to show that gender is essential to a job in order to be able to essentially restrict it. We have the Pregnancy Discrimination Act of 1978, which extends the coverage of all this to pregnancy, to birth, and the medical conditions associated with it. So again, it's very difficult to discriminate based on gender, harder than religion. Now, some cases are about hiring or firing, but other cases, what happens is that employers make it so difficult to retain the job that you quit or that you want to quit. And this is called constructive discharge. Again, you can sue under this. You can claim that the employer knew or had reason to know what they were doing, that they were a member of this protected class, and this discrimination resulted. All right, let's talk about sexual harassment. And this really opens up a difference, and I really prefer to use gender a little bit different than sexual. Gender to me establishes, if we're just dealing with the binary state, and for a moment let's just deal with binary state, male or female. Sexual deals with acts related to sex, the verb sex, to have sex. So when we're talking about sexual harassment, we really have got two different types of cases here for sexual harassment. We've got the easiest one to see is quid pro quo, this for that. The other one is hostile work environment. So quid pro quo, we say, you give me sex or I'm going to fire you. You do this for me sexually or I won't promote you. Now, hostile work environment is something that's a little bit different. A hostile work environment refers to the entire atmosphere around which are you tolerating jokes about sex and rape and assault. Things like that can get you in trouble. Now, coverage is very broad. It can be a single incident, although it's going to have to be pretty bad for that really to result in. And it can be harassment of other persons. It doesn't have to be harassment of you. You can see another person getting harassed and feel it's created a hostile environment for you. If a supervisor is engaging in this, they can make the entire company liable. And this can be maintained even if there's no adverse consequences are suffered. So if I come to you and I say, if you give me sex, I'll give you a promotion, but I won't fire you. And you won't give me sex. Okay, and I go to the next person, I say, if you give me sex, I'll promote you, and they give me sex. Okay, and they get promoted. Well, you essentially, by declining sex, are not getting a promotion, even though I didn't punish you. So harassment by coworkers and non-employees, this can also bring about lawsuits, particularly if the company knows and does nothing about it. And this can even include independent contractors that can harass someone, and if the person that hired them knew, that can make the company liable. Typically, what you get for rewards under Title VII is going to get reinstatement. If you lost your job, you're going to get back pay, any promotion and damages. You will get compensatory damage if there's intentional discrimination. You'll get punitive damage only if you can demonstrate malicious or reckless indifference. Now, discrimination based on age. This is a little bit more, let's just jump in. The Age Discrimination and Employment Act of 1967, the ADEA, covers people over 40. And what it did was it said, first of all, many companies prior to 67 had mandatory retirement age. They would say, when you hit 65, you must retire. And basically, the ADEA says, no, you can't do that. If you've got 20 or more employees, you can ask someone to retire, but you can't mandate it. You make a prima facie case by showing you're one of these individuals, usually over 40, usually older than that you're qualified for a position from which you were discharged from, and you can show an inference of discrimination. So usually that you're replaced by a younger worker. If you're replaced by an older worker, yeah, you don't have a prima facie case. The burden is now on the employer to show why you were discharged. States seem largely exempt to most of this. Now, another big one is the ADA, the Americans with Disability Act. This covers employers, again, with 15 or more employees, so small mom and pop store is not covered. You must make reasonable accommodations unless an undue hardship is created. So what's their prima facie case? You show a disability. More about what disabilities are in a minute. You show that someone is otherwise qualified except for any disability, and that they were excluded based upon that disability. Again, you then file with the EEOC, they can investigate, and if they don't act, you can act. So what's a disability? Well, it can be a physical disability, such as broken limb or loss of limb, loss of hand, anything like that. But it should limit a major life activity. There needs to be a record of it. You've got to prove you have this impairment. Now, there can be exclusions, certain mental conditions, for example, kleptomania. If you suffer from the mental disease of kleptomania, which is an irresistible desire to steal, I don't have to employ you in a bank. HIV is covered even without symptoms, but your disability is not covered if corrective equipment can fix it. So if you say, they won't hire me because I have poor eyesight to do this job, and they say, well, why don't you wear glasses? And you say, well, I don't want to wear glasses. Well, then you can't sue under this. Reasonable accommodation. The employee should tell the employer what accommodations are necessary. If it is an undue hardship, which is a significant difficulty or expense, then the employer often doesn't have to do this. If we're talking about job applications and pre-employment physicals, these have to be open to everyone. And of course, they can't ask certain questions unrelated to a job. So if I was hiring you to run a forklift, I couldn't ask you questions like, are you married? Dangerous work, any health or safety claim, it can be a significant defense to ADA. If you say, well, we have to have someone that's got both arms on this line that's producing this thing because it's very dangerous otherwise, that would be a good defense against the ADA. Reasonable accommodations, some of the things are things like addiction. Now, addiction is actually covered, although use on the job is not. So former addicts, people undergoing treatment, are protected, as are alcoholics, but people that are actually drunk on the job or high would not be. You have to give people equal access to health plans, although, again, now this has changed, obviously. You can exclude some pre-existing conditions, and you can put caps on coverage. A lot of those have been waived. Again, it's up in the air given the changes in the law that seem to be pending. Some of the defenses to employment discrimination. One, you didn't make your prima facie case. You had this duty to show this, this, and this, and you didn't show it. Two would be business necessity, and this is a good one if you can show it. A definite connection between the job qualification and the limits. So if you said, we're working on this line and we need someone who's got the ability to stand because someone that's in a wheelchair or something couldn't reach the line of the things coming down the production line, and the floor is dangerous for anything that's wheeled vehicle, so we need someone to be able to stand. That'd be a business necessity. Bona fide or bona fide occupational qualification. This will work for everything but race. It's impossible to really construct something with race. Seniority systems. Now you can defend a current system as fair, even if in the past it created a problem. So you can have too many men or too many white men or things like that. It's not necessarily fatal to your argument as a defense. After acquired evidence of employee misconduct, usually finding out a real flaw later only limits damages, not a complete defense. So if I hired you believing one thing and it turned out later that it wasn't true, but that's not why I discharged you, that limits damages, not defense, like later costs. All right, we'll talk a little bit about affirmative action now. Basically, this was the idea that in the past there was substantial discrimination based upon things like gender and race and religion. So the federal government said, if you are an otherwise qualified individual, companies, colleges, institutions can give you extra points in consideration. This is often it's done in college. So let's take the college as an example. You apply to a school, and the school says you have to have a 3.0 average. Everybody to get in have to have a 3.0 average. Well, everybody has it. All right, now we say, well, we want a racially diverse class, so we're going to give some extra admission points to people of a different race. You might say, well, isn't that discriminatory? And the answer is yes, it is. But you got to remember that colleges are free to give extra points to people because they're a legacy, because their parents went to the school. Or they can give extra points because of geographical diversity, that, oh, we want people from out of the country. So yes, some people are going to suffer under this. I don't think that's a defense. Those that want to defend affirmative action saying nobody suffers. But affirmative action is subject to intermediate scrutiny. Um, Strict quotas are generally unlawful. Is it dead? I would say affirmative action is in a lot of trouble. I would say at best affirmative action is on life support. And we're going to leave it there because this new Supreme Court, I think, is almost uniformly hostile to it, and I don't think you need worry too much about it. What about state law? Well, some state laws can be very broad. Some states, like California, um, have much broader protection. North Carolina's is relatively weak. I wouldn't count on that. Okay, quick lecture then. We'll stop there. That's the last lecture. I hope you enjoyed the course. Maybe I'll see you all, or maybe you'll hear me in business law too. Good night.